welcome back. Let's bring in Alexander Volokh, a law professor at Emory University School of Law, who has clerked for two Supreme Court Justices, Samuel Alito and Sandra Day O'Connor. Welcome to the show. I guess, what is your opinion or your thoughts about the ruling that we saw in the LGBTQ plus case?
Well, the opinion came out on pretty much expected grounds. The opinion was written by Justice Gorsuch, and it was 6-3, and there was a dissent from Justice Sotomayor with Justices Kagan and Jackson. So the 6-3 lineup is exactly the lineup that you expect and that we've seen in other cases. And basically what the Supreme Court said is that Colorado cannot force somebody to create messages that they disagree with. It's a matter of the First Amendment. It's a matter of compelled speech. And so this is a very strong vindication of free speech rights. This court, in fact, the U.S. Supreme Court for the last decades has been very strong in the protection of free speech. We probably have the strongest First Amendment regime that we have ever had in this country, and stronger than in most countries. And I think this lines up very nicely with it. It's a very strong, full-throated protection of everyone's free speech rights, including when you make wedding-related websites, that the state, no matter how good and how honorable its purposes, just can't force you to endorse a state-approved message.
And look, at first blush, I think most Americans, if you say, hey, can the government force you to say something, I think most Americans would go, no, I'm not comfortable with that at all. So it's a matter of walking that fine line between open discrimination and how they draw that line. Because then I wonder if the website designer or the baker doesn't like Asian people, trans people, black people, women, men, whoever. How do we prevent it from going so far? I mean, how do they draw that line here?
Well, I think the baker is a very good example, and this came up in a previous case. So bakers, wedding photographers, and so on. This set of facts comes up regularly, and I think what's very clear with bakers, for example, is the government can force you to sell to everyone. The government can say you cannot refuse Asians, you cannot refuse gay people, you cannot refuse blacks or women or men or whoever. So selling a cake off the shelf, yeah, you have to serve everyone. If the government wants to have that rule, it can. But what it can't force you to do is write the message, "I love Asians," on the cake, if you don't want to do that. It's legal in this country to be racist. It's legal in this country to say racist things. And that's one of the most important things of the First Amendment, that we protect the speech we hate just as much as the speech we love. And if we didn't, we would not have free speech in this country. So yeah, they can make you serve different people. And in fact, this particular website designer was willing to serve everyone, just like the baker in the other case was willing to serve everyone. But if it's a matter of creating expressive designs, speaking or writing or photographing or creating expressive designs, anything that counts as speech, the government, no matter how honorable its anti-discrimination intentions, just cannot force you to speak in favor of a state-approved message. It has to always leave you free to insist on the message you agree with.
Let me just practically understand that, because this is really fascinating. If I'm the baker and I'm against gay marriage, I have to sell you the cake. You, Tom and Tim, walk into my store.
Come in the door.
But if I tell you, but if they tell me I want you to write, congrats on your wedding, Tom and Tim, on my cake, I can refuse to do that because that's an expression which is different than the actual sale of a physical item like a cake. Is that yes or no a fair summation?
That is precisely correct.
Okay, got it.
So if they didn't want Tom and Tim on the cake, then it would be fine, right?
Right.
If they just came in and they said, "Oh, we saw this cake in the window, we want to buy it," and then under Colorado law, the baker has to say yes, just like it would say yes to anybody. The baker can't say, "No, I won't sell you this generic cake because I don't like gay marriages and you guys are gay." So the baker does have to sell that cake equally to everyone, but if it's a matter of writing a message or designing a particular artistic design with maybe two grooms on it instead of a groom and a bride or whatever, if there's a kind of personalized expression, then the baker is entitled under the First Amendment to say, no, you cannot force me to speak in ways that I disagree with.
And that's why the fact that this woman is, or says she is a website designer, is important because that website is what constitutes the free speech part of her argument, which is why we saw the ruling that we did. Let me just ask it again. There's legal theory in our country, and then there's how life plays out on the ground for those of us who don't wear a black robe for a living. And number one, if you're a gay couple, why would you want to go to a place that does not support you? Why would you just go to the bakery down the street that would love to make you a big gay wedding cake? And if you're a business, you exist to make money and profit, why would you turn down anyone's debit card or cash if you're looking to make a business? There's a practical part of all of this that, for all the legalese, those two issues is kind of what it comes down to. If you don't want me here, I'll take my money elsewhere.
Yeah, well, so Colorado is an example where that statute can be enforced by private individuals, but also it can be enforced by a special government anti-discrimination agency. And that Colorado government agency has been really statute exactly the same agency as in the master. So they've been very aggressive to abide by the statute, even if it's expressive. So it's not a matter of gay people coming in. In fact, in this case, she didn't have any customers yet. She wanted to expand her business, and she went to the agency and said, would I be able to do this? And the agency said no. And that's why she sued. It's because the agency is so aggressive in forcing this regime on everybody. And as for why would you want to turn down someone's cash, I think it's very easy. America was built not just on free enterprise, but on the idea that people have a right to their religious beliefs and people have the right to free speech. And so I think we encourage, and we should encourage, people to live their values. We should encourage people to say, yeah, sometimes there are things more important than money. I mean, in this case, she's religious. I can't say I really identify with those particular beliefs. Those are the beliefs she has. And, she is entitled to say that free enterprise is great. I love free enterprise, but for me, my beliefs are more important than that. And I will turn down money if it means that I have to say something that violates what to me is the truth. I disagree with her views, but I think that in general, that impulse is admirable.
And yesterday there was another case that was decided that related to freedom of religion as well, with the postal worker who didn't want to work on Sundays. Is there any sort of bar or level of proof of how religious you are? That is this really specific to religious beliefs, or can you just say I don't like it? I'm not religious at all, but I don't like it. Is there any where is that kind of barrier in both of these cases?
Yeah, I think that's a really good question. I think what's important to realize is in today's case, the wedding website case, it came up like the facts involve religion, but it's not a religion case at all. I mean, I could just say, look, I'm totally atheist. I just don't like gay people, and I don't want to put this message up. So this is not a religion case. It's a pure free speech case. On the other hand, yesterday's case, it was not a constitutional case. It was under the anti-discrimination laws, and the anti-discrimination laws said that employers have to give reasonable accommodations for religion. And so that means that if I have my employees and my employees say, I'm Christian and I won't work on Sunday. I'm Jewish and I won't work on Saturday. I'm Muslim and I won't work on Friday. Or, there are all sorts of different religious views. Religions have all sorts of a great variety of religious holidays. I won't work on this day or that day or something like that. If people have those kinds of religious beliefs and they ask for accommodations, the statute says that employers have to give reasonable accommodations. So that's not the Constitution at all. It's just Congress passed that law. And the question is, how much of an accommodation are you entitled to? And the law just says that the employer has to give that accommodation unless it would be an undue burden on them. So it's a balancing of of the religious employee's interests and the employer's interests. And if, for example, if it's something where you don't work on Sunday, but the employer has enough people that they can rearrange shifts, and it would be no problem for the employer. That means the employer has to give that accommodation. And that was a unanimous case yesterday.
Right. All right, Alexander Volek, thank you so much for joining us here today. We'll be right back with more on the Supreme Court.